Good evening, I'm Dike Rostant. Welcome back to the TTT News. The last time we had our guests, we were able to speak about a great many things from the Labor Relations or Conciliation, Advisory and Advocacy Division. We are now going to be speaking about formal filing of a trade dispute at the Ministry of Labor as well as retrenchment. We are going in-depth on the work of the Labor Relations or Conciliation, Advisory and Advocacy Division with Ms. Sabina Gomez, Chief Labor Relations Officer. It's time for In-Depth with me, Dike Rostant. Welcome, Ms. Gomez. This is the third time is a charm. We're very happy that you're able to make the time. How are you?
Oh, I am fine, thank you. And thank you very much for inviting me back on the program to just inform and educate the working population of Trinidad and Tobago.
All right. Now, the last time you were here, we spoke about informal processes. We spoke about the statute of limitations. We spoke about maternity leave. We did not talk about filing trade disputes. So I want to start off with that, thank you, in terms of who can file or report a trade dispute?
Okay. All trade disputes are reported to the Minister of Labour first off. And under Part 5 of the Industrial Relations Act, Section 51(1), the employer can file a trade dispute. That's 51(1)A. The Recognized Majority Union, 51(1)B. And 51(1)C, any union of which the worker is a member in good standing. This is like walking off the street clientele, and they can go to any trade union of their choice and seek representation if they feel aggrieved.
Now, I asked that question, and I'll ask the flip side of that. Is there a definition of who cannot make such a report?
Okay, that's a good question. Because, you know, we have had persons trying to report trade disputes. Okay, attorneys at law who represent workers, they cannot report a trade dispute under Part 5 of the Act. Industrial relations consultants, they cannot report, and the aggrieved worker. Now, only two pieces of legislation where the aggrieved worker can make representation, so they can report their matters. That is under the Maternity Protection Act, and that is under the Retrenchment and Severance Benefit Act, which has provisions for the individual worker to report their matter directly to the minister.
And with that, I want you to take me through the process of timelines, because I know there is this period of almost like a fortnight. And so what is the process of saying, okay, well, this is the problem I have, and these are the channels to take them through? All
right. In terms of when the dispute is reported to the minister has 14 days within which to call parties in, whether it be the trade union, the employer, and to come to conciliation. Within that 14-day period, the dispute, once it's a valid trade dispute, the dispute is acknowledged and an invitation is issued to parties within the 14 days to come to conciliation. Now, within the 14 days period, the minister has locus in that he has authority to call the parties in for conciliation. Now, when that 14-day has elapsed, the matter is deemed to be, if there's no conciliation, the matter is deemed to be an unresolved dispute, unless parties agree, because the law makes provision. If for whatever reason parties cannot meet within the statutory 14-day time period, both parties will have to agree by signing an extension of time pursuant to Section 55(2) of the Industrial Relations Act to agree to a date that both parties will agree to extend the time to allow the minister to have further conciliation or to conciliate on the matter if there was no conciliation to begin with. So this is something that practitioners are well aware of. So there's that 14 days, and then there's provision for parties to extend the time beyond the 14 days to allow the minister to conciliate on the matter.
Well, Ms. Gomez, we like smart man thing in Trinidad and Tobago. You know. Do people try to game the system in terms of saying, okay, well, you can't reach me, let us take this thing to court? What happens after those 14 or 15 days?
Well, very good question. Sometimes the both parties, sometimes the union may refuse to come for whatever reason. They may have had probably bad relations with the employer from before. They may have met and they were not successful, so they would say, look, I'm not coming. Let's go down to the court based on the type of issue it is. We want to take the matter down to the court. Sometimes the employer may want to conciliate and the union may not want to conciliate, and sometimes vice versa. Some employers may say, look, I am not unionized. Why do I have to come to the ministry? Why do I have to come to conciliation? There's no union on my job. We are not a unionized company. Then I will have to explain to them, even as far back as the Constitution, there's freedom of association. And the law makes provision that any worker who is aggrieved they are free to join a trade union and have their matter come forward, even as far as the industrial court. So the system is voluntary. The compulsory aspect of it is within the 14 days. But after that, it's voluntary. There's nothing to compel that you have to come through conciliation. The law, and maybe the type of system we have is for mature societies, because it is voluntary. At that stage, I usually inform parties that the ownership of the dispute belongs to the employer and the trade union. When it reaches to the court, the court makes the decision. At conciliation, parties have ownership of it. They can negotiate, they can sit down, discuss, say what they want, how they would like to settle it, and really negotiate and come up with a win-win. Sometimes you may not get everything that you want, but at least you feel satisfied when you leave that we would have worked together towards some goal, and the worker at the end of the day and the employer would leave satisfied.
And with that, I want us to take a short break and we come back, because I want to know a member who is not unionized, if there's not a trade union at their work, even though there's the freedom of association, or what are some of the things you need to do, whether or not you need to join the union. But we talk about that when we return. We're speaking about the work of the Conciliation, Advisory and Advocacy Division with a Chief Labor Relations Officer, Ms. Sabina Gomez. Stay with us. We return with more. Welcome back. We are going in depth of the work of the Conciliation, Advisory and Advocacy Division with a Chief Labor Relations Officer, Ms. Sabina Gomez. Thank you so much for staying with us. Now, Ms. Gomez, just before we took the break, I was asking, what do I have to do for a union to take up my case?
Right. Well, the worker can go to any union of their choice if they are not unionized. If you have a recognized majority union within your organization, then I would advise you to pay your dues and become, financial, because if anything occurs in the workplace, you will have no one else to represent you. Now, in the case of an organization where there's no recognized majority union and the worker is free to join any union of his choice, in order for the matter to be deemed a proper dispute before the minister, the worker must be a member in good standing. Now, let me explain a little bit about the membership in good standing. Now, once the dispute reaches the minister, 8 weeks prior to that date, the worker is supposed to pay the dues to the union. So the authorized body to check membership in good standing is the Registration, Recognition and Certification Board, which is external to it's all under the umbrella of the Ministry of Labor, but it's an external body. Now, one of the things that happen, those are the challenges that an employer could make. If the employer is organized, the business is not unionized, the employer could then come to the ministry once the dispute is filed within the 14-day period and raise the question of membership in good standing. So two things they can raise. They can challenge and say, hey, this worker is not a member in good standing of the union. I just terminated the services of the worker. He could not have been in the union for that period of time, so I want to challenge that. So once that challenge is made, now the other question that the employer could challenge is worker. The employer could say, that person is not a worker. He has an effective voice in policy formulation. The person is a manager. he has responsibility in terms of carrying out policy of the organization. So all of these are two questions that the employer could raise to challenge a matter that is reported to the minister. So once those two questions are raised, the minister has no choice but to refer those two questions to the registration board so that the board could verify whether A, the person is a member in good standing of the union, or B, whether the person is a worker under the Act. If the person is deemed not to be a worker under the Industrial Relations Act, then that person will have to go to the High Court to take up their matter. So those are the challenges. There are other challenges that could be raised in terms of the law specify that the reporting party must copy the other party at least by hand or registered mail. They must, if they're reporting the dispute to the minister, they must inform the other party. And so an employer could come and say, hey, the union I never received this dispute by hand or registered mail. And we will have to write the other side union, did you give the employer the dispute by hand or registered mail? And if they cannot prove it, then they have to refile again. Or in the case where it's a recognized majority union and the employer may complain that the union did not go through the grievance procedure, there were no bilateral discussions, and we want the matter to be remitted so that bilateral discussions could take place. So those are the challenges that could arise, even as the minister is about to acknowledge the dispute as a proper dispute, or even when he acknowledges the dispute as a proper dispute. Within that 14-day period, these are the challenges that could arise, and their actions in terms of the consequences of the questions that either party, the union could raise in case the employer reports the dispute. The union could raise a challenge and say, hey, you didn't go through the grievance procedure, or we didn't receive a copy by hand or registered mail, and vice versa with the union. The employer could then raise membership in good standing and worker within the meaning of the Act. So those are some of the issues that could be raised. But
one of those issues that you spoke about in terms of the employer saying, I terminated this person, it brings to mind the issue of redundancy, retrenchment, and how that figures into this equation.
Right. Okay, now redundancy. Now we're talking about redundancy is at the, is at the employer's initiative, the initiative of the employer, where there is, as a matter of redundancy or surplus labor could occur. So there's retrenchment at the initiative of the employer because of a situation of redundancy. And redundancy is where there's surplus labor in the organization. And, during this COVID period where there was no work, there was shut down, a lot of workers, employers retrench workers. A lot of employers, rather than retrench, they choose the layoff. Now, a layoff could be initially for 3 months, but because of the situation that we found ourselves in, which was really unprecedented, there were extensions were made to that layoff, sometimes 6 months, and even beyond the 6-month period, because, the court said that initially you have 90 days, but, in case of, extreme circumstances, you could extend that beyond that. So we have had that situation with COVID where, a lot of layoffs occurred, a lot of retrenchment would have taken place, where there were no other options for the employer in terms of finding alternative employment for these workers. Sometimes the employers would indicate that, look, we don't really want to lose the workers, but as it is right now, so sometimes they will enter into negotiation with the worker in terms of shorter hours, whether they would proceed on vacation leave. There were different initiatives that were used, and some unionized environment, the employer would have sat with the union and discussed how we're going to go forward. Some organizations and the recognized majority union would have drafted up MOUs or terms of settlement in terms of how they will get over this hurdle to overcome this unprecedented occurrence.
And speaking of hurdles and unprecedented occurrences, you and your team would have recently put out an advisory. What was that advisory covering, and why did you see the need to actually put this out and say, okay, well, we need to share this?
All right. Well, during the COVID period, even though we were not deemed to be, how should I say, we were out at work because we realized a lot of things were happening in the workplace, and even though we were deemed not to be essential, we were out to work because we realized that workers needed help. They had queries, they had complaints, and they needed someone to, to be there to hear them, to, put things in place, just give them basic advice in terms of what to do. And employers likewise, because, employers were calling us, look, we want to do the right thing, to give us guidance. So we were out and about, and one of the things that we noticed is, based on the emails that we were getting and based on the queries that we were getting, the numbers in terms of, because under the Retrenchment and Severance Benefit Act, employers must report to the minister where they have 5 or more retrenchments, and what we found and what we are hearing and looking at the numbers, it was not adding up. So what we did, we drafted an advisory and put it on the newspaper in terms of, businesses that were closing, whether the law requires 5 or more workers to be retrenched, and if there were whatever, sometimes employers may do, they may retrench 2 workers 1 month, 2 workers, and so the numbers would maybe more than 5, but because they're not doing it 5 at one time, the minister may not be getting that report. And so we thought it prudent, just because you must have an idea of what is taking place in the country, especially at a time, of unprecedented job losses and all of that. And the numbers were not adding up in terms of the figures that we were getting coming into the ministry. So that's why we felt it prudent to put out that advisory.
Okay, and with less than a minute remaining, Ms. Gomez, what is the one thing that you want someone to come away from this conversation thinking about or remembering?
In terms of just to know what your rights are, because a lot of workers will come to the ministry and say, I don't know that I could have gone to a trade union to report a dispute, and they will wait 2 years, sometimes 3 years down the road and not be aware. Your matter is only alive for 6 months, So after 6 months, your matter is statute barred. So therefore, you have 8 weeks to become a member in good standing. So you have to be aware of time frames. If you're not sure, just call the ministry. Our numbers are, 299-0300, our extension 2043, or you can email us at conciliation.mol@gov.tt. Soon we will be introducing a helpline, and that will be specifically for sexual harassment cases. We have special email shcaad@gov.tt. That is also for sexual harassment cases. So we try as much as possible to cover everyone. We try to maintain the law in terms of having meetings within the 14-day period. We try as much as possible. We are very short-staffed, and we really are working miracles in the Conciliation division to keep the unit afloat.
And we want to thank you so much for providing that yeoman service, Ms. Sabina Gomez, Chief Labor Relations Officer, the Conciliation Advisory and Advocacy Division. And we want to thank you on behalf of the entire TTT News team for joining us. This has been In Depth.